Did you apply for unemployment and now the EDD has set up a phone interview with you? Hi, my name is Adam Geratovac and I'm a California employment lawyer located right here in San Jose, California. And a lot of people right now are applying for unemployment because just like any other part of the year, people are getting laid off, people are getting terminated, and people are looking for new jobs. So one thing that the EDD is now doing is they're setting up and conducting phone interviews with individuals not 1 week in advance, but about 1 month to 6 weeks in advance with everybody. Now the EDD is still allowing you to submit your certification, so you're still entitled to receive unemployment during that time while you're waiting for your interview. However, there are a couple things that a lot of people need to be aware of prior to accepting those payments. Number one, you need to be entitled to unemployment benefits. If you're not entitled to unemployment benefits and you are certifying for benefits for that time period before you have your interview, the EDD will still pay you money. However, if it's later determined that you're not entitled to unemployment benefits, you'll have to pay that money back plus interest, plus any potential fees that they may tack on. Now, there are two ways that you will be entitled to unemployment. So number one, if you're fired or terminated. Now, when you're looking at any type of termination, I believe that even if you're a poor worker and if you're making good faith mistakes and you're fired because of that, you're still entitled to unemployment. Now, there are a couple reasons where you would not be entitled to unemployment. The number one reason that will restrict you from obtaining unemployment is if you quit your job. If you voluntarily quit your job without a good faith basis, then you're not entitled to unemployment benefits. Now, you're going to hear a lot of attorneys tell you that, you can always quit and still get entitled to unemployment benefits, but, I think that might be more link baity because when they're talking about those very narrow exceptions, they're talking about the exceptions, not the rule. So generally, if you quit your job, you're not entitled to unemployment benefits in the state of California unless your employer forces you to quit. Now, one thing that you need to look into is who is the moving party of that quit. For example, are you going up to your employer and saying, hey, I don't think this is working out for us right now, so I would like to quit my job and how can we set that up between us? And then they fire you right there. Now, you would say that you're fired at your employment. If I were the employer, I would say that the employee first tried to quit their job. They first tried to separate themselves, and because they're in the moving party of that separation, I just ended it right then and there. Now, in that type of situation, I think the employer would win, and I don't think the employee would be entitled to unemployment benefits. Now, let's look at a different situation. Let's look at a situation of where your employer comes to you and says, hey, this isn't working out, we're going to fire you in 1 month, but we're going to give you the opportunity to quit if you want to save face or if you want to exit on any way you want to. Now, in that situation, if the employee does quit afterwards, I believe that the employer is the moving party because the employer is the person or the people who initiated that separation. Even though you're the person who ultimately quit, your employer is the one who gave you the option to quit. You see what I'm saying there? The second reason that you will not be entitled to unemployment benefits is if you are terminated for misconduct. Now, the EDD's website has a really good frequently asked questions section on what constitutes as misconduct, but I like to explain it like this. That's a good way. If you get terminated for repeatedly violating corporate policies, if you get terminated for willfully and negligently completing work improperly that cause a lot of issues multiple times, then I don't think you're entitled to unemployment benefits. If you start swearing at your manager, if you start swearing at customers and colleagues before you quit or before you're terminated, you may not be entitled to unemployment benefits because that cussing, that swearing, those interactions that you're having that led up to your termination could be seen as so far out of the bounds of your normal employment that it will be seen as misconduct. So if I could have a couple bits of advice for everyone, if you're about to be terminated, I would say do these things. Don't do these things. Do not swear on your way out. Do not cuss at people on your way out. Do not yell at anyone on your way out. And most importantly, do not sign any agreements, waivers, or settlement and release agreements on your way out because you're not required to. Now, this is a good thing to remember because if you're terminated, you might be given a severance or separation agreement. Now, in the state of California, if you're over the age of 40, whenever your employer provides you with a severance or separation agreement, they need to provide you 21 days to review that agreement with an attorney. Now, thanks to Governor Gavin Newsom, starting January 1st, 2022, anytime any employee is provided a separation agreement, they need to be provided at least 3 days to review that agreement with an attorney, with themselves, or just at least have the opportunity to review it with an attorney. Now, let's go back to the unemployment side. So when you're preparing for your interview with the EDD, you're going to be on the phone with an individual. This individual is going to ask you questions about your employment, including your dates of employment, your date of termination, your rates of pay, what your typical schedule is like, as well as why you were terminated. So if you were terminated and your employer says, hey, this just wasn't working out for us, tell that to the EDD representative. Tell that to the CUIAB law judge, because in those situations, they are just trying to put together a story. Now, the story that they're putting together is also going to be including facts that they receive from the employer. So if your employer is telling you something different than they told the EDD, you need to bring that out in that telephone conversation. Now, this conversation is not going to last very long. It should only last around between 5 and 15 minutes. But after that point, after you provide all the details about your employment and your termination, you will soon receive a decision, a determination. Now, if you're entitled to unemployment benefits, great, good job. Certify for your unemployment benefits, look for a job, and just try to keep on getting employed, because that's the ultimate goal, is to get another job. If you are rejected, if your unemployment application is denied, then you have 30 days from you receive that letter to appeal that determination, to appeal that decision. Now, if you don't get your application or your appeal in within 30 days, you're not SOL, but at the same time, I wouldn't want to risk that, because if you turn in your appeals application after 30 days, the first question that the administrative law judge, the CUIAB law judge, is going to ask you is, why was your application for appeals late? And if you don't have a good reason, if the judge doesn't believe your reason is good enough and reasonable, then you don't even get to appeal your case. They just say this appeal was filed untimely, and then they'll throw it away. So if you get denied unemployment and you feel like you were wrongly denied unemployment, file an appeal immediately. File an appeal immediately. Even if you just write on a piece of paper, I appeal, and then you write all of your social security number, your case number, the right addresses that you need to send it off to, that'll be okay, because they will still have notice that you want to appeal the determination. Okay? All right, so now let's say you get past the interview process, you get denied unemployment benefits from the state of California. Within 30 days of you receiving that notice of determination, you file for an appeal. Great. Now, right now, it turns out that the CUIAB is, like a lot of other administrative agencies and bodies, governing bodies, they are behind due to COVID-19. So if you are receiving an appeal, or if you get scheduled an appeal, it might be in a few months from now. I know when people are filing wage claims with the Division of Labor Standards Enforcement, those wage claims are getting pushed out 6 months to even a year from now. So just be patient. Now, while you're filing for that appeal, or you're waiting to receive that appeal date, you will still be eligible to certify for your benefits. Now, I guess this is the time where you should really discuss with an attorney or someone who really knows the UI code, because if you are ineligible to receive unemployment benefits, even after you appeal, you'll be found to be ineligible to receive unemployment benefits. But if the appeal finds not in your favor, then you'll still be required to pay back all of the benefits that you received during that whole time you were certifying for your benefits. You first applied all the way up to your appeal. Now, that's a lot of money. And when you start looking at the money you have to pay back and the interest and the potential fees and penalties they may tack on, it might not be worth it. So speak with an attorney or someone who knows the UI code to really give you an honest answer of whether you should be eligible to receive unemployment benefits. Now, our office receives calls about unemployment insurance and the EDD all the time. Unfortunately, it's one of those situations where that individual does not need to set up time for an hour-long consultation, because they don't have an hour-long of analysis that we need to go through most of the time. But at the same time, they still sign up for like a 30-minute case analysis, because that determination on whether you're entitled to unemployment benefits or not can mean the difference between you receiving your unemployment benefits or you having to pay back $2,000, $5,000, $10,000 in unemployment benefits at the end of the year. And for anyone, that cost is a big surprise. So if you have any other questions about how to apply for unemployment, whether you're entitled to receive unemployment under the UI code, or if you have an appeal that's scheduled and you want help with some representation or at least a consultation to help you tune your story and help provide you information on what to expect in that CUIAB hearing, give our offices a call. You can find the link in the bio or go to adamjthelawyer.com. Now, thanks everyone for tuning in to this video, and stay tuned for the next one. I promise they'll be very informative.